show off with the mystic. Merhaba.
Merhaba.
Marhaba.
Marhaba.
Shalom.
Shalom.
Selam.
Salam.
Assalamu alaikum.
Wa alaikum assalam.
Beautiful, Mumtaz.
That's great.
Brilliant. Okay. It gives me great pleasure to welcome Dr. Borgac Ergene to the University of Cincinnati and the Taft Research Center, and to thank the Taft Foundation once again for bringing great talent to our campus and some of the leading scholars in fields of interest to our students and faculty. And Dr. Borgac Ergene is such a star in the burgeoning field of legal history and Middle Eastern history. He's one of the innovators that are changing the way that we see legal history from a static series of texts to actually seeing what happened when people went into court. He's published a very well-received monograph with Brill, one of the leading publishers in the field of Middle East studies, and over a dozen articles and peer-reviewed publications in the last decade. He has won all the leading fellowships for study and research in the Middle East, which is really remarkable because he was doing his graduate work at OSU, and I guess they do some things right up there. We don't like to think about that, but you know. And he has been an invited speaker and a workshop participant in the US, Europe, and in the Middle East. He took his degree, his bachelor's from Middle East Technical University. He took a master's in economic history at the London School of Economics and Political Science. Took another master's in economics at Middle East Technical University in Ankara. And he took his PhD with distinction at Ohio State University in 2001. And his dissertation won the Malcolm H. Kerr Dissertation Prize, which is awarded by the Middle East Studies Association of North America for the best dissertation in humanities, which is a very prestigious and competitive award for him to have won. Today he's going to present some of his work, which I hope will give you a very different picture of how law works in the Islamic world, or worked in the Islamic world. And he also gives us the benefit of taking the focus away just from the capital cities of Istanbul and Cairo and looking at provincial history. So in every way, this is a very innovative scholar, and he's going to present to us some very cutting-edge research, and I hope you will bid him welcome.
Thank you.
Excellent handouts, you guys. So, wow, that was some introduction. A lot of it's exaggerated. It's just, it's very kind for Dr. Frierson to introduce me in those terms. I'm very happy to be here. Thank you for all of you for attending to this talk. Thank you, Lily, Dr. Frierson, for inviting me and allowing me to share my work with you guys here. I'm particularly happy by the fact that I'm back in Ohio again. I'm not only in Ohio, but in another football school like OSU. I miss college a lot. You know, I teach at UVM, and football hasn't been there for a while. It's great to be in the same atmosphere, essentially. Although we are still living anyway, so just remember. So I would like to talk today about this very short entry, case entry in the court records of Kastamonu. This case entry involved, is relevant to, is about this rape allegation. It's a very short allegation, and I'm hoping that in the process of discussing that rape allegation, I would like to talk about the ways in which Ottomans dealt with those kind of issues. And also from a more historiographical point of view, the ways in which Ottomanists dealt with the kind of cases that they found in court records. The context, Kastamonu is a location, is a township in north-central Anatolia. It's a small place, medium to small-sized township with about 30 to 3,000 households at the center. And it's, as Lily mentioned, it's a location that's far from the center of the empire. And I've been working on the court records of Kastamonu for a while, and it gives me an understanding of legal processes in environments such as this one, which are not very well known, but very representative of the locations outside of Istanbul. And I will start with this particular case that I would like to focus on. This is the number one case number one in your handout. So this is as it goes. One day in January 1788, a woman named Ummu Gulsum bin Ali of Hacı Tursun neighborhood or quarter in the town of Kastamonu came to court and made the following claim against a man by the name of Mehmet. his full name is Mehmet bin Hassan, who is living in the same quarter. This is what she said. A while ago, this Mehmet took me to his house by force, where he took my virginity against my wishes. As a result, I became pregnant. I would like him to be questioned in this court. I would like his statement to be recorded and what is required by law be implemented. When questioned, Mehmet denied Ummu Gulsum's allegations. The court then asked Ummu Gulsum to produce evidence, which she was unable to do. Consequently, the court forbade Ummu Gulsum from insisting on her accusations without providing any kind of proof. There exist, in fact, many such entries in customary court records that I am familiar with, which reveal, in fact, unsuccessful litigation attempts by women against men accused of sexually assaulting them, abusing them. In many such cases, women did not seem to be too concerned about the fact that they are bringing a case to court without providing any kind of evidence. This is curious because according to Islamic jurisprudence, according to Islamic law, false or unsupported accusation of adultery, like in this case, is a hot crime, which is, according to Quran, a crime against God. And it has severe consequences. In this case, for example, if Ummu Gulsum is convicted of committing this particular crime, she was supposed to be given 80 lashes, just because she's making a claim and she's not being able to support it in the case, in the environment of the court. However, there exists no evidence in court records that women like Ummu Gulsum were punished because of such accusations. Yet this observation does not explain why they would approach the court without making sure that they could prove their cases. Leslie Pierce, a very important and prominent legal scholar who's focusing on these kind of issues, also encountered similar kind of rape and sexual harassment cases in 16th century Aintab, another location in Anatolia, which is kind of far from Kastamonu, but still on the same peninsula. Pierce's explanation for women's tendency to bring such cases to court is primarily extrajudicial. That is, she says, women came to court not necessarily to win their cases, but to make their voices be publicly heard and be able to tell their sides of the story, share those stories with the community essentially, regardless of the legal consequences of these kind of choices. In her words, I'm quoting from her, one of the court's primary functions is to act as a forum for voices from the community. It gives public status to voices that might not get otherwise a hearing. The court record inscribes the people's stories permanently in community's historical memory, especially in the area of sexual crime, where the attempt of bringing an accusation against another can so easily turn into wrongdoing by the accuser. Speaking publicly in court may be the only way of defending one's honor. Emphasis on the term honor. She's defending her honor publicly, regardless of the consequences of such an action. In her morality tales, Pierce provides a sophisticated reading and interpretation of Aintab's court records by providing socio-political backgrounds of the court's operations and situating its actions in the local context in which they took place. At the same time, Pierce's interpretation of women's motivations in unsubstantiated rape and abuse cases is in line with the ways in which Ottomans had traditionally portrayed Ottoman courts and their actions. They represented Ottoman courts primarily as arenas of litigation and adjudication, where conclusions to court processes is zero-sum verdict. Only one party wins, that is, in economic terms. Accordingly, and assuming that Ummu Gulsum and other female litigants in her position possessed a basic knowledge of judicial responsibilities associated with bringing such a case to court, the only explanation, Pierce and others would contend, for initiating a litigation that one was unprepared to substantiate is coming to court, not for an immediate judicial resolution, but to accomplish a non-judicial objective. In other words, Ummu Gulsum went to court knowing that she was going to lose, but that was not important to her. Her objective was different. Her objective was extrajudicial. She wanted to win in the court of public opinion. Yet, this interpretation assumes that courts were involved only in litigated processes. In her interpretation of similar types of cases, Pierce seems to overlook the fact that evidence was necessary just for adjudicated processes, litigations that is, and not for mediation or arbitration. And by disregarding the possibility that disputants could go to court seeking some form of mediation or arbitration, Pierce effectively limits the court's operations to adjudications only, to adjudicated processes, litigations. However, she is not the first person to do this, first historian to do this. According to Chaim Gerber, another very prominent legal historian of